Hey everybody. Let me take a moment to say hello. Hey Black Beauty. Hey Rita. Hey Reba. Hey Sierra. Hey. I'm trying to get um my watermark because I know Missy over here is gonna be like, "Where's your watermark? Where's your watermark?" So I'm putting my watermark on here because I have to how's everybody doing? Well, today, y'all, I rested. I hung out with my family. I had a good time today, guys. I really had a good time today. I cannot complain. I had an awesome day. Awesome day. Hold on a second. Gotta close these things out so I can have these things to you guys. Okay, I think I got it. Hello, Queenie Dina Ellis. Hello, Perspective. How are you? Okay, let's see. All right, I got some info for y'all. Y'all wondering why is she coming on so late? Well, to answer your question, I don't have to go to regular court early. I'm going to well, let me just put up who I will be talking about today. I am going to be talking about the following individuals on this screen here. Let's see. These are the individual I will be talking about today. These are the individuals I will be talking about today in a few minutes. Ernesto, YoungThug, and Mr. Kelly. All right, I'm going to be reading the most recent motion for YoungThug, and also I'm going to finish off the motion that I was reading for Mr. Kelly in regard to those lawsuits, and I wanted to bring to you guys attention what's happening with Ernesto's case. Tomorrow I will be going to court because there is a hearing tomorrow in regard to Ernesto, and it looks like there is like a plea deal going on. The other cases that were supposed to be indictments, they still have not been indicted yet. There's charges, but I don't know anything. Remember the most recent charges? They're just charges. They have not been indicted yet. So I'm going to court. There's court tomorrow. I will be sitting in the courtroom to be a witness of what happens, and I'm going to bring you back the 411 on that. Now, next we're going to talk about YoungThug. You guys remember last week? There was some heated conversation in regard to some of the motion and discovery and all that. Well, I just want to tell you that Mr. Steele filed a motion. He filed a motion, and I am going to read the motion. And motion is for remedy. And that's 17 pages. So, but before I read his, I'm going to go ahead and read Mr. Kelly's the rest of it, because I think I only got about 5 pages left, 8 pages, and this one here is 17 pages. So I'm going to read the hey Jericho. I'm going to read the one from RKelly first, okay? I'm going to read that, and then I'm going to read Thugs. Okay. I'm going to do more paraphrasing with his, but Mr. Kelly's, I'm going to go ahead and finish reading that for you guys because I started and it's been taking me a couple of days. So today I said I was going to finish it off. Okay. All right. So, okay, I'm going to go ahead and read. I'm on page 17 page 18. I didn't know I was already on page 18. I'm on page 18. I'm going to go ahead and read that off for you guys because I was told that they hate the voice of that lady and they prefer for me to read it. Okay. I put out a question on my community board and I don't see too many people responding to that question. The question is more of supporting the channel. People think it's just monetary support. No, support is not just monetary. Support is sharing it, watching the videos, participating, typing comments in the comment area. That's support. That is what support I'm talking about. I'm not talking about just monetary because I know folks don't have it like that. I know times are rough and I understand that. That's not what I'm talking about. I'm talking about fully supporting the channel as in being an active participant in the channel. You know, you showing up is you supporting, like you guys that's here now, you're supporting the channel. But I'm just talking about just, going on forward that you hit the like button, you share it, you just spread the word, hey, Tall Glass. So that's what I'm talking about when I'm talking about support. Or give suggestions. Send me email if something you like or this didn't like, or what you want more, what you want me to look at, stuff like that. That's support. Being interactive in the channel. That's the thing I'm talking about, not just financial. People think it's financial. No. It's not just financial. It's being active in the chat, being active in the channel, supporting, make it spread. That's what I'm talking about. That is what I'm talking about when I say support. And even responding to my question and give me your feedback. That's what I'm talking about. I don't know why people always think it's always about money. Lord have mercy. More life than just money. I know money answers things, but it's more to life than just money, okay? I'm talking about being, human. You know what I'm saying? Being human. You're killing it with the interviews and trial updates. Oh, thank you, Tall Glass. See, this is the kind of thing. You see how Tall Glass is giving me feedback? That's what I'm talking about. Interacting, make this a us thing, not just me giving you information and you just sucking things up and not, let us have a relationship going on in here, okay? That's what I'm talking about. Because then you're going to make me feel like, okay, why am I doing this? That's good, but when you pull transcript things they want to hear, yeah, that's, of course, no, I'm not saying no money. I'm not saying no money. Those who can do with the money, yes, definitely. But hey, Tasha, but I'm just saying, like folks be wanting so much, but they're not giving. They're not giving like in their time. Like for example, I'm gonna use you for example, Black Beauty. Black Beauty, she just don't only bless financially. Black Beauty support that she's in the channel. She's always, she shows up. That's number one. She shows up. She participates, and she decide to be a strong mod for me. You know what I'm saying? That kind of stuff. Okay, let me get started because I don't want to be here all night and you guys not get anything. Okay, I'm gonna go ahead and read RKelly's, and then I'm gonna read Thug's attorney's motion, for motion for remedy. That's what it's called, motion for remedy. But I'm gonna go ahead and read Mr. Kelly's because I know everybody's not here for the same thing. Because I got a message today that one person, she says she's here for the Young Thugs case. She's not here for affirmation. She's not here for RKelly's, but she's here for Young Thugs. So, and she says she's been disappointed because when I have those closed meetings, you don't get a chance and blah 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 blah. But I want to give a shout out to Tiffany. Tiffany gave me some tips, and I really appreciate her. You know, people give you complaints, but they don't give you solutions, and that's what I was asking for, solutions type of stuff. Hey, pretty brown eyes. Okay, let me go ahead and start. Okay, okay. Thank you, everybody. For those who are here, appreciate y'all. Please stay active in the chat. You know, communicate. I only ask don't cuss each other out, no fighting. But other than that, interact with one another because that helps the algorithm as well when you interact and talking with one another in the chat. All right, let's go. Page 18. Page 18, number 76. I think that's where I was at. It says plaintiff were not entitled to default judgment on a cause of action of negligence where the plaintiff did not plead or prove all elements of negligence claim. Negligence was an apt legal theory advanced because plaintiff failed to timely file a lawsuit for a claim of assault in IED. That's what it said, IED. Against Russell, absent and adequately pled negligence claim. Plaintiff negligent infliction of emotion distress failed. Number 77. Minimal defendant Kelly and RSK have pled here a meritless defense to plaintiff negligence in denied cause of action. Denied is IED, cause of action. Number 3, this court compensatory and punitive damage award against defendant Kelly was erroneous abuse of discretion. 78, for the reason identified, plaintiff were not entitled to default judgment on their IED claim, which was time barred, and they simply did not plead all necessary element of negligence. 79. But even if plaintiff had sufficiently pled a cause of action of negligence against defendant Kelly, they could not have conceivably satisfied their burden of demonstrating that defendant Kelly acted with malice or evil motive when he played no role in the threat call and did not even know defendant Russell had engaged in this conduct. 80. As stated, plaintiff complaint does not allege that defendant Kelly Defendant Kelly directed defendant Russell to prevent the lifetime screening of Newhouse by making a false active shooter's threat. Nor could it where text messages identified in Plaintiff Exhibit 2A shows that defendant Russell acted alone without defendant Kelly's knowledge. 81. Because the standard of punitive damage is a strict one and punitive damage will be awarded only in exceptional case, the conduct justifies such award must be manifest spite or malice or a fraudulent or evil motive on the part of the defendant or such conscious or deliberate disregard of the interests of others that the conduct may be called willful or wanton. Miller versus Silverado Trucking. And there's a case number on that one. Number 82. Simply put, Defendant Kelly committed no intentional act against the plaintiff. Even the plaintiff complaint established that Defendant Russell acted alone in carrying out this stunt for his own personal and wacky reason. She put wacky reasons. That the U.S. Attorney's Office never indicted Defendant Kelly, and they have not been shy about indicting Kelly. Further, demonstrates that Defendant Kelly was not personally involved in this incident, and that Defendant Russell was acquitted of any conspiracy inviting the jury's belief that he planned and carried out this threat alone sealed the deal. 83. Thus, there was simply no grounds to award any punitive damage against Defendant Kelly. Defendant Kelly should not be subject to punitive damage simply because he is R. Kelly. It was not this court's duty or obligation to further punish Defendant Kelly for his separate criminal conduct, which he has been prosecuted, charged, and sentenced. 84. Defendant Kelly and RSK more than satisfy his burden by making a prima facie showing of numerous meritorious defenses to plaintiff complaint. Indeed, plaintiff were not even entitled to a default judgment, having failed to adequately plead a negligence claim, which is inapplicable to the conduct alleged in this complaint. B. Defendant Kelly had no knowledge of this lawsuit at any inquest hearing until after learning of the $10.5 million judgment entered against him from a third party. Alternatively, his failure to respond is inexcusable. 85. As set out above, Defendant Kelly would have prevailed on a motion to dismiss plaintiff complaint. Unfortunately, he had no notice of the complaint or any subsequent proceedings. The docket shows that plaintiff continued to serve Defendant Kelly at the MDC Brooklyn long after he was transferred to MCC in Chicago. Plaintiff's counsel not only failed to give Defendant Kelly notice of her motion for default, the order of default or notice of inquest, she made no attempt to contact undersigned counsel to inform her of these proceedings. 86. Defendant Kelly has been under a constrained, unrelentless onslaught of criminal prosecution and civil lawsuits since 2018. Since his incarceration on July 12, 2019, Defendant Kelly has been inundated with lawsuit and legal paperwork that he cannot differentiate from one another on account of his illiteracy. 87. For context, the following is an incomplete list of dozens of lawsuits and prosecution against defendant Kelly, of which undersigned counsel is currently aware that were pending at the time of defendant detention at the MDC in Brooklyn when he was allegedly served with the instant lawsuit. Neither undersigned counsel nor defendant Kelly can even say with certainty whether this list is exhaustive. United States versus Kelly, 19 CR 286. And she lists a whole bunch of court cases on here. She lists 1, 2, 3, 4 cases of Robert Kelly, people versus Robert Kelly in Cook County. I didn't know it was that many cases, y'all. There's 1, 2, 3, 4 cases that was against them. Then you have 2 cases with the federal, the 4 cases with state, Minnesota, Midwest Commercial Funding, which is the the guy, the landlord. Then you have another one here, Williams versus Kelly. Then you have the Faith Rogers versus Kelly. Then you had Jane Doe versus Jane Doe. That's the one from that girl, Prado girl. Okay, you had that. Then you had Bryant versus Kelly. That one's out of Michigan. There was Bryant versus Kelly out of Michigan. I never heard of that one. Wow. Okay, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 cases against, let me count again. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Yeah, 12 cases. Number 88. Although plaintiff have filed a certificate of service indicating that defendant Kelly was personally served at MDC on December 1st, 2021, he has no recollection of receiving such lawsuit and conceived that he have no ability to read and comprehend its meaning at any event. 89. Defendant is functionally illiterate. On June 6, 2022, Dr. Daniel A. Martel, PhD, conducted a forensic neuropsychological examination of defendant Kelly. Dr. Martel found that Mr. Kelly has significant impairment in all areas of academic functioning, placing him in the bottom first of 3rd percentile of an early elementary grade, 1st to 3rd grade overall. Wow. Did y'all hear that? Did you guys get that? Did y'all hear that? Did you guys hear that? The doctor did a neuropsychological exam and found that Mr. Kelly is on the bottom. Oh my God. I'm going to read that one again. And this is a doctor. It says here, he did a neuropsychological examination of defendant Kelly. Dr. Martel found that Mr. Kelly has significant impairment in all areas of academic functioning, placing him in the bottom first of 3rd percentile and at an early elementary school level. Example, first to third grade overall. See, this is what I was saying. All those people who hey Eric, hey, how you doing? All those people who start talking all this crap. See, okay, let me shut up. Let me just read, y'all. Let me just read. Let me mind my business and read. Okay. This was a forensic examination report by Dr. Park Diaz on page 14, Exhibit H. Defendant 90. Defendant Kelly lacks the skill to read many the words of complaint and to comprehend them. A first to third grade would have no ability to understand the importance of or the meaning of a plaintiff complaint or differentiate it from 100 of other legal documents. Defendant Kelly received, while incarcerated at MDC Brooklyn, sometime through the mail, and sometime hand delivered by correctional officers and law enforcement officers. 91. On December 1st, 2021, Defendant Kelly had been recently convicted of RICO charges and was facing a sentence of life in prison following the jury's verdict of guilty in late September 2021. Defendant Kelly was placed on suicide watch and was overwhelmed by his upcoming sentencing hearing, where he faced a sentence of life imprisonment. His second federal criminal prosecution in the Northern District of Illinois, and his various pending state prosecution in the state of Illinois and Minnesota, to mention nothing of the numerous civil lawsuits. 92. In December 2021, Defendant Kelly was also in the process of changing lawyers. Indeed, his entire trial team withdrew from the case in and around January 30, 2022. Undersigned counsel first joined Defendant Kelly criminal defense team in and around October 29, 2021 to handle post-trial motion and his appeal in the Second Circuit. But the scope of her representation quickly expanded with the departure of his trial attorney 3 months later. Undersigned counsel had no knowledge of and was not apprised by anyone about the pendency of this lawsuit. To describe this period of time was complete chaos is an understatement. 94. Even if defendant was personally served with the complaint and summon, he received no notice whatsoever in connection with the plaintiff's motion for default filed nearly a year later, nor did he receive notice of the default order, the notice of issuance, the state of readiness, or notice of any inquest despite this court order requiring plaintiff to make such notice. Exhibit A. 95. The record reflects that all notices after the filing of complaint were made to MDC Brooklyn by the defendant, but Defendant Kelly departed the MDC on July 11, 2022, and was detained at the MCC in Chicago. 96. Plaintiff had actual knowledge that Defendant Kelly was not at MDC Brooklyn as of September 2022, where his Chicago trial was widely reported in the news, and Plaintiff Van Allen actually testified against the defendant in the trial at the Chicago trial. A simple inmate search on BOP database would have shown Defendant Kelly's whereabouts also. 97. Moreover, there was no excuse for failing to contact Defendant Kelly's counsel at the time plaintiff moved for default. Undersigned counsel was easy to find with a quick Google search by simply pulling up the docket from his federal prosecution. 99. To be clear, Defendant Kelly did not have a team of lawyers to assist him in his legal matter. After his conviction in the Eastern District in late 2021, his resources were entirely depleted, and the government quickly acted to restrain him from using any monies he might have access to hire counsel. 100. Defendant Kelly was incarcerated, illiterate, and without resources to keep a team of civil lawyers on hand to handle his corpus legal problem constitute inexcusable default, particularly where plaintiff made no effort to properly serve him after the filing of the original complaint. 101. The right to be heard as contained in the due process clause is a cornerstone of our system of justice. United States Constitutional Amendment. Okay, let's see. It is undisputed that the due process is violated unless the opportunity to be heard is afforded at a meaningful time and in meaningful nature. The controlling principle, as well settled as a matter of general policy, disposition of controversies on the merits is favored upon a proper showing of excuses and absence of willfulness. Brandon versus Antonio, and she has a case law on that. 102. New York's court have found that incarceration can be the basis for excusable default. They gave a case number on that. In order to merit relief from default, there need be no finding that the defendant was completely incommunicado, or even that he did not acquire any knowledge of that action. ID, for example, in Brennan, the court observed that during a crucial period of service and for the almost 2 years thereafter, the defendant was substantially disabled from protecting his interests in the case on account of his incarceration and that upon of his release. It would be reasonable to expect that the defendant would falter in giving attention to all his complicated personal and business affair. ID. 103. While the facts of Brennan are unique, the case is instructive insofar as it directs court to look at the particular circumstances of the defendant to determine whether his failure to answer the complaint was willful. 104. On this record, there can be little doubt that Defendant Kelly's failure to respond to his complaint was not willful, but rather a product of his incarceration, illiteracy, and departure of his legal team that around the crucial time of service. 105. Most importantly, after the initial complaint was allegedly served, Defendant Kelly received no notice in any further proceeding because plaintiff inexcusably served him at MDC Brooklyn, at least according to his own notice. Notice, even though he was detained at the MCC in Chicago. 106. Defendant Kelly had no knowledge of the inquest and would have been unable to transport himself to New York from North Carolina in any event. 107. Defendant Kelly's fundamental right to be represented, to be, I'm sorry, Defendant Kelly's fundamental right to be present at the hearing was infringed. Upon where everyone in the courtroom knew how to find him and made no effort to do so. 108. Defendant Kelly did not learn that he had been sued and judgment entered against him to the tune of $10 million until it was reported in the news after this court entered its decision. Conclusion. This court's order of default judgment against defendant Kelly must be vacated. 110. 110. Defendant Kelly has shown that plaintiffs were not even entitled to defendant's judgment and further has demonstrated numerous meritorious defenses to the claims. 111. Defendant Kelly has also demonstrated excusable negligence for failing to, excusable neglect, excusable neglect, I'm getting tongue-tied here, excusable neglect for failing to respond to a complaint he had no recollection of receiving and that he would not been able to read and understand in any event. Moreover, defendant Kelly received no notice for the order of default or notice of the inquest hearing. Number 112. Accordingly, this court should enter an order vacating the default judgment and return the clause to the docket for resolution on the merit consist that with defendant Kelly's due process right, even RKelly is entitled to a due process of law. Respectively submitted, Jennifer BonJean, September 17, 2023, New York, New York. BonJean Law Group, PLLC, 750 Lexington Avenue, 9th floor, New York, New York, 10022, and then the phone number. And to all party via ECF, electronic transfer. All right, so that was it. That's the end of Mr. Kelly's lawsuit response. Okay, now I do have the one for Faith. Remember, Faith filed suit by herself. I'm gonna read that. It's only one page. I'm gonna read that one to you guys. Nobody can compete with Mr. Kelly in R&B industry. Hey, Jericho, you're right. Okay, y'all, hold on a second. Let me go ahead and get that other one for you so you guys can hear what happened. What's her response? And I'll keep my eyes out to see what, because I don't think anybody's paying attention to this. As far as the news people, they're not going to tell you when good news happened for Mr. Kelly. They only tell you when the bad stuff happened. So I will be keeping my eye on this. And I'm telling you, definitely it's going to be thrown out because she gave some good reasons for it to be thrown out because they were serving it when he was not even there. You know, they did the initial one. Supposedly he received it, but he couldn't even read it, couldn't understand what's been written. And she got documented information from the doctor telling where his capacity of understanding those legal documents are. So I know it's going to be thrown out. It's going to be vacated. I know that for a fact. So that's something we don't even have to worry about. Let me go ahead and pull up the one with hold on a second, y'all. Let me pull up the other one. The Faith Rogers one. Okay, hold on. Okay, the Faith Rogers one, they had a conference, right? And it looks like they're gonna have okay, hold on. I'm gonna read to you guys what it says. Hold on. Okay, the Faith Rogers one by itself, they met. Okay, I'm gonna show you. Oh, she's gonna get me if I go open this up and start showing without my watermark, so I'm not going to show it. Okay, I'm reading the paperwork. It says Rogers, comma, Faith A versus Kelly Robert S. Has the index number, and it says the appearance on September 19th, 2023, which was a couple of days ago, right? Yeah, a couple of days ago, because today's the 24th. So September 19th, which was, I think, last week, I guess. September 19th, there was a conference held in this case, and the parties that appeared was you had the not present, the plaintiff's attorney was not present, but they were in Maryland, and they said per diem counsel sent. So I guess they had a per diem counsel sent. I don't know what that is all about. But who showed up for Mr. Kelly was Tom Farinella showed up, and Jennifer BonJean showed up for Mr. Kelly on last week on the 19th. And it says the court has to consider this case of the court has considered the status of this case. And it doesn't say it has determined. It says the parties apparently agreed to mark this matter off the calendar while criminal case is pending. So I guess they're gonna hold off on doing this until they're gonna have another hearing on October 31st at 10 a.m. and it's gonna be in person. So that's with the one with Heather Williams. I mean, not Heather. Oh, Lord, I got Heather Williams. Faith Rogers. So they're going to have another conference on the 31st of October. So, guys, y'all can put that down on your calendar. This is the one with Faith Rogers, okay? So Jennifer did meet up with them, but their counsel was not there, but Tom was there. So anybody have any questions on that one? Any question? So I just gave you guys update on both cases, the one with Rogers by herself and the one that all those other people was on. It was Faith Rogers was in that one, her mother, the guy Pratt, the other guy Gartrell, whatever his name is, and Lizette Martinez. So she's gonna have that case vacated, and the other one they're gonna postpone it and have a hearing because Jennifer is dealing with the has to respond once the state is going to respond on next week. What day is next week? The 1st. Hold on, not the state, the the feds. Next week is we need the 31st. Let's see what day is 31st. I don't know. No, Monday is the Monday is the 1st. Next Monday, I think. Yeah, next Monday is the 1st, right? No. Sunday. Next Sunday is the 1st. That's when they're due. The paperwork is due for them. Yep. Next Sunday is the 1st. You said Monday is the 1st? No, this calendar says Sunday is the 1st. Because it's only 30 days in September. Hold on, let's see. I'm trying to check the date for you. Yeah, Sunday. Yep, Sunday is the 1st. Thank you, Ruby. So yeah, Sunday is the 1st. Okay. I was like, I know I ain't crazy. I'm looking at the calendar. Okay. So that's the update from Mr. Kelly. Now, if folks just jump off, y'all. You should see them jumped off. These people funny, Lord have mercy. Okay, now let's go ahead on. I'm gonna go ahead and read Mr. Steele's motion. Let me go ahead and put that up on my screen. And I know you guys probably, why she didn't put the RKelly, because I want people to do their own work. I'm not doing the work for them no more. Not. Mm-mm. Should know your payday. Okay, let's go ahead on and let me show you Thug's paperwork right here. All right, here's the remedy. I'm not doing the work for people. Okay, here we go. We're gonna go here. We're gonna do the remedy. All right, here we go. Do y'all see this one? Let me see. Y'all don't see it. Let me take the Let me take this off. Okay, there we go. And I think I'm gonna just paraphrase it. It's basically what happened in court. Mr. Steele put it in a motion, and it says here, motion for remedy based on intentional statutory discovery violation as well as intentional prosecutional bad faith that has caused prejudice by violating Mr. Williams' constitutional right to a fair trial, constitutional right to effective assistance of counsel, constitutional right to present a defense, and constitutional right to prepare for a trial. Whoa, y'all. Steele is not playing with them. Whoa. He put it in the docket. Ooh, child. So it's gonna be some fireworks. I hope I get I hope they send a camera person, because I need this. We need to see this and as it unfold, don't we? They're gonna have some motions going on next week. They need to have whoever it is, the camera person. I'm gonna contact Tony. I'm gonna see who's a camera person that needs to get on the ball and do the work. You know what I'm saying? They need to work their behind off and stop playing around. Stop playing with us. Okay, let's see what you guys are saying. Yes, Tall Glass, we need the camera there. We need the camera there because it was so chaotic last week. I mean, I tried my best to give you guys what I could. Okay, let me go live on hold on, let me go on Twitter. I mean on IG for a second, y'all. Let me go on IG. Hold on a second. Sorry. My bad. Look, guys, let me tell you something. Hold on. Let's see. I'm going live. Hey, IG folks. I am live on my YouTube. Get ready to read the motion that Attorney Steele submitted for YoungThug. And if you guys could come on over to the YouTube side, and you'll get a chance to hear me read the motion. Basically, it's a remedy motion, and I'm going to read what it says. It says motion for a remedy based upon intentional statutory discovery violation, as well as intentional prosecutional bad faith that has caused prejudice by violating Mr. Williams' constitutional right to a fair trial, constitutional right to effective assistance of counsel, constitutional right to present a defense, and constitutional right to prepare for a trial. So guys, if you guys come on over to to Infamous Sylvia on YouTube, you get a chance for you to hear me read it. Because it's hard for me to hold the phone and be on here at the same time. Maybe, hold on a second. Let me try it this way. Ugh. And y'all won't be able to see anything, but y'all could hear me, right? Give me a thumbs up if you can hear me on IG. You won't be able to see anything, but you can hear it. Thumbs up. IG people? Because I'm trying not to, I can't hold it. It's hard for me to read and hold at the same time. Can y'all hear me? Ebony? Mr. Rennell? Y'all can hear me? Okay, they're not there. They're gone. Okay, come on over to the wild side, to the YouTube side. Those who come on over to YouTube side, and you guys will hear me read the motion that Brian Still submitted. Mr. Williams, Mr. Williams' attorney, Mr. Brian Still. Okay, so come on over, and I'll read it over that side for you guys. All right. All right, I'll see you on the other side. Come on over to YouTube, Infamous Sylvia on YouTube. Bye. All right, you guys ready? All right. State of Georgia versus Jeffrey Williams, defendant. You guys got the indictment page and everything, right? And it says here, I read the motion already. Now comes Jeffrey Williams by and through undersigned counsel and hereby files this motion for remedies based upon intentional statutory discovery violation, as well as intentional prosecutorial bad faith that has caused prejudice by violating Mr. Williams' 1. Constitutional right to a fair trial. 2. Constitutional right to effective assistance of counsel. 3. Constitutional right to present a defense. And 4. Constitutional right to prepare for a trial in the above referenced case. In support of this motion, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all charges in the above referenced indictment. 2. The prosecution present this case to a grand jury on or about May 9th, the same date, May 9th, 2022, the same date that Mr. Williams' arrest. 3. Mr. Williams immediately filed for a statutory demand for speedy trial and advised this honorable court and all parties properly of same. Furthermore, Mr. Williams has timely asserted his statutory demand for a speedy trial upon re-indictment and when Fulton County order under judicial emergency were expired. Mr. Williams was arraigned on or around summer 2022. And pursuant to OCGA 17-16-3, a witness list was due at or before the time of this arraignment. 4. At every bond hearing, Mr. Williams brought before the honorable court the prosecution argument that there is not any condition of bond that could be fashioned by the honorable court to permit Mr. Williams to have his statutory right to bond pending trial. Additionally, the prosecution always announced that they were ready for trial, so there would be no delay in Mr. Williams' trial date, and that would cause that will be caused by the prosecution, and therefore Mr. Williams' custody would not be extended by prosecutional delay. After requesting, demanding, and moving for discovery immediately after Mr. Williams' arrest in year 2022, the prosecution announced to this honorable court and the parties that one, discovery was ready to go, and that the state had the discovery index to make it easy and accessible for Mr. Williams to understand, same, and two, that all witnesses were identified on a witness list with all valid, current, statutorily required information. On June 2022, the parties were advised by the prosecution that the discovery was so large that defense counsel needed to bring 8 terabyte TB drive to Fulton County Chief Deputy District Attorney Don Geary on date certain, and all discovery would be immediately provided. On June 8th, 2022 and June 16, 2022, undersigned counsel wrote letter that his co-worker was able to hand deliver to Fulton County District Attorney's Office on the date and time as directed by the prosecution. An 8 tera TB hard drive to District Attorney Geary, Esquire. See attached letter dated June 8, 2022 and June 16, 2022. District Attorney Geary did not meet with the law clerk as promised, and the law clerk was turned away from the district attorney's office empty-handed, as the district attorney's office unilaterally, in direct violation of their promises and representation to this honorable court and the parties, decided that discovery would be served in a different way. All right, let me see what you guys are saying. Hold on. Okay, I was just reading what you guys are saying. Okay, number 6, discovery has been sent piecemeal via 12 staggered production over the next 15 months, with the most recent production being served upon Mr. Williams at the end of July 2023, which is 8 months after all discovery will supposedly be fully produced pursuant to OCGA 17-16-3. OCGA 17-16-4, OCGA 17-16-8, and more than 14 months after the district attorney promised that all of the discovery was ready to be provided to Mr. Williams, the complete witness list with statutorily required information that has not been provided. Hold on. Provided to Mr. Williams as of Monday, September 19, 2023. Further, the prosecution recently announced that additional discovery is still forthcoming. Shockingly, the most recent discovery cache served in this end of July 2023, Discovery Production 12 along contained a half terabyte of discovery with 3 million PDF pages, 250,000 videos/audio files, and more. Number 7, once a witness list was served on Mr. Williams by the prosecution, which finally occurred on December 2022, approximately 5 months after mandated by OCGA 17-16-3. It was met with a motion, and that said witness list was not complete pursuant to the statute. See motion for complete witness list dated December 12th, 2022. Attached here too. The prosecution's next witness list was served on January 2023, adding more witnesses to the trial. Again, this witness list failed to meet statutory requirement. On Monday, September 11, 2023, District Attorney Love was asked by the Honorable Court whether Brian Steele's counsel for Mr. Williams representation that the state added 266 additional witnesses to the Friday, September 8th, 2023 witness list was accurate. District Attorney Love denied that the representation was accurate and responded instead that the state had also served a witness list on February 22nd, 2023. However, as conceded on Wednesday, September 20th, 2023, District Attorney Love represented that the existing service of a witness list on February 22nd, 2023 was wrong and Mr. Steele was correct. No witness list was served on February 2023. District Attorney Love also relied on a third witness list that was filed on March 13, 2023. However, this document does not conform to the rules regarding a witness list as this March 13, 2023 document merely contained names of people without any contact information whatsoever, in violation of the law, spirit of the law, and the letter of the law. Mr. Williams' counsel was correct that the September 8th, 2023 witness list included 266 additional people who has never been identified in any meaningful way as witnesses in Mr. Williams' trial. Number 8. In the case sub judice, the prosecution's bad faith is nothing short of egregious as the witness list and all discovery was ready to go since June 2022. The prosecution has deliberately not served same upon Mr. Williams for 15 months and counting. Furthermore, a total of 308 witnesses were hoisted upon Mr. Williams and other accused on September 20th, 2023. To compound the prosecution outrageous misconduct and prejudice to the accused the discovery served upon undersigned counsel on July 2023 contains a list labeled "Do Not Serve Yet." This is reprehensible, and that the production of any discovery was willfully, knowingly, and in bad faith delayed. See attached screenshot of discovery. Former prosecutor Gary stated that all of the discovery was wrapped up with a bow on June 2022. The prosecution's gamesmanship and bad faith is clear to a casual observer. The prosecution has violated the law in effort to gain a tactical and unlawful advantage over Mr. Williams, and has violated Mr. Williams' above referenced statutory and constitutional right to intentionally wait until months before opening statement to put forth critical discovery and a proper witness list in this ep- epitome. Oh, I don't know what I'm doing. Epitome, epitome, whatever. I'm sorry, y'all. Of bad faith and prejudice, Mr. William. Number 9, y'all, I'm getting tired. I'm starting seeing stuff double and triple and stuff like that. All right, I'm sorry. I'm back. On or about Monday, September 11th, 2023, this honorable court put its hammer down, explaining in clear and unequivocal terms that it is unacceptable for the prosecution to add 266 people to the September 8th, 2023 witness list. This honorable court ordered the prosecution to provide a proper, lawful, constructed witness list within 7 days on Friday, September 15th, 2023. The prosecution provided the defense with another witness list, which added more witnesses to same along with previously omitted statutorily required information on the witness list. This proved bad faith and prosecutional misconduct, as it is evident that the prosecution poses all of this witness contact information and intentionally withheld said information. Whoa. The prosecution's misconduct has not stopped. On Wednesday, September 20th, 2023, the prosecution added another 37 to 43 witnesses on their latest witness list. Whoa, y'all. Dang. Hold on. You guys are you guys hearing this? Are you hearing this mess? Are you guys hearing this? Are you guys, come on now, give me some feedback. Are you guys hearing this? Okay. Davey, you're the only one that's talking up in here. Everybody else fell asleep. All right, let me go ahead and finish. Me too. Okay. All right. They added 43 people now, okay? The prosecutional misconduct continues and violate Mr. Williams' above referenced constitutional and statutory right. It is clear that the state believes it can continue to violate long-standing rules, laws, and constitutional protection with impunity, and his honor will simply sit by and do nothing. Oh my God, y'all. Ooh, child, y'all. Oh my God. Do you guys hearing this? Without sanction and imposed by this honorable court, the state will continue to engage in bad faith and misconduct in the case at bar and beyond. Oh my Lord, y'all. The honorable court has consistently ordered the prosecution to provide its witness list and all discovery to Mr. William, respectively. This honorable court has failed to enforce. Oh my God, y'all, do you hear this? Debbie, do you hear this? Oh my God. Yeah, oh Lord. Oh my God, he's putting it on paper. He's put it on paper, y'all. He put it on paper. Hey, Miss Fat. He put it on paper. Okay. All right. Let me go back. Okay. He said basically the judge has not done anything. He said this honorable court has not yet given a remedy for this grave continued misconduct, bad faith, and prejudice. Steele is mad, y'all. Steele is mad. Oh my God. Whew, this is some stuff. Oh my God. Okay. Thus, Mr. William respectfully requests that this honorable court consider the following remedies. Okay, here's the remedies that he's given. Okay, y'all ready for the remedies? Calvin. Put allegedly. Please put allegedly on their comment, please, because I don't want nobody coming after us in here. Put allegedly, Calvin Lee. Please put allegedly. Please. Allegedly. We are not going to be trying to get in trouble for nothing that is said in this chat. Allegedly. Okay. We don't know nothing about no relationship. Allegedly. Okay. And the words and the people in the comment is not the words of the host. Not my words, okay? Don't come after me. So I have to put it in on the on the airwave because I don't want folks Tasha K and me. Okay, let me finish. Okay. Now here's the remedies that he says the judge needs to do. Number 1, all 308 new witnesses be excluded. All discovery and discovery 12 that thereafter be excluded from trial. The prosecution continues with its obligation to provide anything that they have not served upon Mr. Williams, that is Brady evidence, Giglio evidence, exculpatory mitigating evidence, and any other discovery that must be provided that is mandated by the law. But none of non-served discovery can be used at trial for the prosecution whatsoever. Number 2, Mr. William. There it is right here, y'all. Mr. William be granted bond as Mr. William has been prejudiced repeatedly by the prosecution misrepresentation. And now, if this honorable court does not exclude these 308 witnesses, undersigned counsel need even more contact with Mr. Williams. It is not constitutionally effective to sit in court and talk with Mr. Williams about this case and to schedule a meeting outside the court while Mr. Williams is in confinement. Mr. Williams needs to be released as a reasonable bond, released on a reasonable bond so that he can be in constant communication with counsel, whether in person or via privileged call, to assist in his defense as mandated by the Constitution. The jail communication no longer is workable upon the prosecutional additional workload that they must be put upon undersigned counsel. Number 3, undersigned counsel is released as well as all accused from the following mandated of OCGA 17-16-3, OCGA 17-16-6, and OCGA 17-16-8, because the state violated and intentionally ignored the code section. Number 4, the prosecution must notify the parties 2 weeks in advance and not the Friday before of the witnesses whom they intend to call and the order they be called at trial, as well as all documents, recording, jail call, etc., that they will seek to introduce into evidence in the 2 weeks to come. Moreover, the prosecutor must provide the names of who is actually coming to testify in court and not rely on 600 people on outline of its witness list. Naming 600 people plus in the witnesses is objectively wrong when compared to the prosecution's announcement that this is a potential 3 month trial. And 5, perform GCIC NCIC history for every lay witness on the prosecutor's witness list and provide same to Mr. William counsel insert. Number 11, as mentioned above, in addition to the additional 266 witnesses initially identified in Mr. Williams' emergency motion to strike filed on September 8th, there are additional 37 to 43 witnesses on the state September 2023 witness list. This cannot be acceptable and lawful in the court of the great state of Georgia. 12. Mr. William also asked the following to be placed upon record and answer in open court. 1. The prosecution state where in discovery the relevant report, video, chat, conversation, etc. is specifically located, as the prosecution has failed to provide any discovery index or order as ordered by the honorable court. 2. Why did the prosecutor state to the honorable court that she served and filed a statutory proper supplemental witness list on February 22nd, 2023, when same is incorrect? 3. Why file the March 13, 2023 witness list with nothing more than the list of name? 4. Why did the prosecutor refuse to serve oral discovery in June 2023 along with the complete statutorily proper witness list as promised? Who made this decision and who was aware of the decision instead of piecemeal discovery by the way throughout the end of September, all the way throughout the end of September 2023? Number 5, who made the decision and who was aware of the decision by the prosecution team to intentionally not serve yet, so the accused would be blind to this mandated discovery until over 14 months after the district attorney's office stated that all discovery was ready, organized, prepared, and to be shared with the accused? And 6, please provide the complete, accurate, and unusable discovery index so that the accused is aware of the discovery and where the same are located to compare the witness list. Number 11, based upon the above, Mr. Williams respectfully requests the Honorable Court to grant Mr. Williams' emergency motion to strike, which is filed on September 8th, as well as this motion for remedy based upon prosecutorial misconduct, bad faith, and prejudice to Mr. Williams, as well as violation of Mr. Williams' above referenced constitutional right to a fair trial, effective assistance of counsel, present a defense, and prepare for trial. Wherefore, Mr. Williams respectfully requests the Honorable Court to hold a hearing on this motion, and at the conclusion of the same, ask the Honorable Court to grant the above request relief. The 22nd of September, 2023, respectively submitted, Brian Steele, and then gave his information. All right, y'all. That was it. What y'all think? What do you guys think? My throat itching. What y'all guys think? Miss Black, I need to ask you a question. Kim, um, Kim, he asking you a question. Calvin Lee wants to ask you a question, Kim. You have to catch a replay? No, hold on, y'all. I agree with you, Debbie. You fell out the bushes? Oh, you behind a little bit. Okay. I'm gonna put my link in there if anybody want to come up and have a discussion on what we talked about, what I just brought up. Come on up, hit the link, hit the link. Here's the link if you want to come up and answer some question. You just if you have any question for me or anything, or just want to say hello or something, whatever. Just hit the link if you want to say hello, and if you want to call in. Let's see if we do. I need to do a call in number. You guys want to do a call in number? He go back to court on Tuesday, Calvin, on Tuesday. He goes back to court on Tuesday. Today's your birthday, Calvin. Happy birthday. Okay, do y'all want to come? How long will the system be able to hold? I don't know. Mr. Steele is not playing. No, he's not. Nope, he's not playing. Oh, guys, Little Rod Dad he's doing an interview with me on Tuesday. I don't know if I'm gonna do it live or I'm gonna pre-record it. I'm not sure yet. I'm not sure yet. My back is hurting me. I need to go lay on the floor. So you guys have nothing to say? Nobody want to hit the link? Everybody want to hide behind the screen? My throat is itching so bad, y'all. All right. Oh, it's good. It would be that's a dream team. Black Beauty. That's a dream team right there. I thought you was off today, Kim. You supposed to be up. You supposed to be up because you're supposed to be acting like you still at work. Oh, you're welcome, Calvin. Hope you enjoy your birthday. Y'all, my throat is itching so bad. This allergy crap is just getting on my nerve. Y'all can see me? Oh my God, my throat's itching. It's like this side. It's like itching me right there. I know you off tonight, but you gotta act like you still at work. You should be supposed to be up, Kimmy. I think I'm gonna go get me something to drink because my throat itching. What's done in the dark can come to light. That's right, Miss Sharon. Sharon, you are so right. Oh my God, my throat is itching so bad. What can I do, y'all? My throat's itching so bad. I don't have no allergy medicine. But do I have some allergy medicine? Maybe I have some downstairs. Courtney, I gotta put my mask on. Let me go. Let me see. Where's my Courtney? It's in the room, and Ronald's in that room, and I don't feel like Courtney, I gotta wait till Oh my God, my throat is itching so freaking bad. My Lord. Oh my gosh. It's really bad. Oh my Lord, Kim, you started this. I don't normally have false allergies, but now it's like oh my Lord, it's really, really bad. Let me go see if I can get me some orange juice or something. Hold on, y'all. I need some vitamin C or something. Hold on. Hold on. Okay, I'm back. I'm back, people. All right, I'm back. I'm back. All right, so all right, I'm back. I got me some little tangerines, so it helped me out with my vitamin C. Kind of touch it a little bit. Everyone, I'm from Chicago. You from Chicago? Calvin? Yeah, I wonder why am I up? I took a nap this afternoon. I took an old person's nap, and I am up. Kim, I took a nap just like you did. And so the Benadryl relaxed me, and I was asleep. I didn't get it. So I'm staying up with Kim. I don't want to come up here. I'm not gonna bite y'all. Who's off tomorrow? Which comment? You want me to play the comments? I need it. I love my senior. Me too, Carolyn. Want me to play it? Okay. Let me play what happened this week. Hold on. All right, let's play it. Which one you want to play? Hey, why not? Which one you want to play? Let's play this one.
Okay, and if I can ask, what do you have in checking and savings? We'll start out
Okay,
with checking first.
okay, we're supposed to be.
Checking right now, maybe like 20,000 something.
So you guys can get to hear what Steele actually said. This tangerine's so little and sour. Why it's not moving?
It is simultaneously with the drive, so the index and the drive should be able to come together.
And do you think,
With the location.
and is that looking like Tuesday or Wednesday?
Yes, that's what I see on.
Okay. And I will make sure that we have a high-speed drive here that they will be able to quickly transfer from their new high-speed to our high-speed. And then we will be responsible for copying that high-speed drive to all the other defendants. Okay?
What about the witnesses? Are we gonna update that?
Oh, that can be done by, for my.
And we're gonna have the coding.
Oh, Tuesday, Tuesday's not gonna be
Tuesday,
on Monday.
okay, Tuesday.
And you're going to email that to us?
Yeah. And, but I already know.
I'm okay with email. Everybody else okay with that? Okay, yeah, you can just email that to us, please.
Okay, so on Monday, Tuesday, I should say, we're gonna have the witness list update. And I would ask that you all color code those particular people that are in custody and those people that do not have phones for whatever reason. Because I'm gonna assume that the state's gonna probably go and locate them via address, or if you've got some other third party phone that, like, if you can't reach, Jimmy, maybe you can reach Jimmy's mama, and Jimmy's mama will tell him, hey, you need to go ahead and come down or be available for us to.
Hey, Angie.
So, if you don't have that particular person, if you have a third-party way of getting in touch with them, and some people who are street folks, that's the way you do that. I mean, some people, unfortunately, they don't have phones and don't want to have phones, but there are other ways to reach them.
Thank you.
So as much as you can tell. For example, I had a witness once in a trial who they knew that came to see the sister every time, first of the month, to get a Social Security check. That's how they reached them. So, whatever you can present or give to do that, I'll check on Monday. So I expect that to be done and updated. All right. So Tuesday, check on the witness list and the format of the drive. So when is the discovery going to be done, Ms. Hilton and Ms. Love? When's discovery going to be,
Barring the new comment, I expect that this should be the last.
when I'm checking on the format and the drive and the index on Tuesday, as well as the witness list. So I know that you just represented to me, it's gonna take a couple of days once you, like Tuesday, I assume you're gonna tell me, hey, we transferred everything to the new high-speed drive. And so how long will it take you all to format that drive into a usable exercise? I mean, like, I'm not, that's just terrible, Ms. Adams, that you would try and put that on a mature man such as Mr. Botts. I think there's a statute that covers that. That's terrible. Exactly. We still haven't seen anything from Antox.
Your Honor.
Mr. Botts. But anyway, yes.
So, Your Honor,
Yes, Mr. Weinstein.
I'm sorry, I'll let Ms. Love finish.
Okay.
I was going to say that,
Tuesday's status is to make sure that the files have transferred, and then you should be able to give me, okay, based upon the file transfer, how long do you anticipate it's going to take you to format that information into usable, searchable folders.
I believe that we can do that by Wednesday if it goes like it should.
Mr. Brown, anything?
Yes.
Yes, absolutely. Okay. Yes, ma'am.
Wednesday,
Wednesday, you should be able to,
yes. And what we can do, because it'll be running continually from either late this evening or tomorrow morning when I get the faster speed computer, we can give the court and counsel for the defendants. We can give the court and counsel for the defendants updates as it is uploading or downloading, transfer
you said that's on Tuesday,
Wednesday.
on Wednesday?
Yes.
tell Glass, tell Glass said lies. Those tangerine helped out with the itchy. I just hope I don't have to get some more.
When will the index be done? Will that be done, I mean, you said Wednesday, I can check on the formatting and transfer your fast hard drive. So when can the index when can we expect that?
Ms. Hilton has told me that we can do that by Wednesday as well, because I'm doing that.
Okay.
And can I just make sure that earlier today.
You just bought some good grapes.
I said that you would give us this new discovery, this additional
I
discovery.
got some mango too. I got mango down there.
To it being included in this compiled.
Then I'm gonna go eat get my mango.
Right, well, that will prevent us from having to hunt through this compiled discovery to figure out what is new. Okay. And I have one last question, Your Honor. Is this it? Are we done? Have you given us all of this? Let me just, I'm asking you, I guess, now. Have you given us all of the discovery that you have? Or can we expect future tranches of discovery, except for discovery that you newly acquire going forward?
Got patted down.
Yeah.
Gotta pat this head of mine
I don't know
down.
if we should be expecting any, because it seems to me that we should be long done with this.
All right.
So can we get an order?
Calvin, I'm gonna go get me some hot tea right now.
Go ahead and grab.
Yes, Your Honor, I will.
Some lemon in it, some
And
honey.
You could get with Ms. Love and Ms. Hilton. Probably confer with Mr. Steele since it was his motion to begin with on behalf of all of you.
So the motion is on behalf of all of them, Angie.
Let's just, if you wanna.
Angie.
I would say, let's just aim for next Thursday or Friday, okay?
Yes, Your Honor, thank you.
Okay, all right. All right. Now we've completed that task. Mr. Curtis, can we examine juror 352, please? Thank you.
What kind of charger do they have? You said what kind of charger do they have YoungThug on? What do you mean charger? What kind of charge? Trinata! Oh, my condolences. My condolences. Thug only has 8 charges, guys. You in Georgia? Okay. I'm back. I'll be back soon. I'm back in Georgia. No, with my mom and dad. Oh, wow. What part of Georgia? Okay, y'all. I'm gonna try and let y'all hear this thing here. And get myself off the screen.
Okay, juror 352, good afternoon, finally.
Y'all want to hear this? No, this part's good boring.
Chair, as close as you can to the microphone.
This part's boring.
And that's
The jury's part is boring, so we don't need to hear that.
okay. That concludes our our jury examinations for today. For your situational awareness councils, before we move on to some other business, for tomorrow, the 21st, starting at 3:30, we will examine tomorrow 307, 316, and 325. Again, 307, 316, and 325. Examine those jurors some more. All right, starting at 3:30. Do we? That means you haven't been paying attention. Yeah, you need to come in just because of that, because you asked me that. Okay, no, we don't have anything else other than that. We start at 3:30 tomorrow with those three jurors, okay? That's all I'm planning on covering. Okay. Mr. Harvey and Mr. Sharp, I have in my possession your motion to declare OCGA 16-11-131 and 16-11-133 unconstitutional, and to bar or strike prior convictions Acts 77, 175, and 191, and current charges counts 53 and 65 based thereon on the facts and circumstances. It has been brought to my attention that our Supreme Court is in fact taking up this issue, and I want to say, Mr. Harvey, we appreciate you providing that they're considering Massey versus the state. Is that correct? All right, and I believe that we're waiting on an opinion from them. Okay. Would it be appropriate for me to wait until they render a decision in this particular case to take this matter up? Well, okay, it would depend on the law that's that exists at the time, right? Now, I mean, right now, those two things are constitutional. You've made an argument about them, but if the Supreme Court were to say, of the United States or the Supreme Court of Georgia, were to rule that these two statutes were unconstitutional, then that certainly would affect those particular counts.
It's almost over, y'all. Hey, nobody want to talk to me, so I'm about to go to bed after this. After we finish this last part, I'm about to go to bed because y'all not talking to me.
challenge on the indictment is the prior felonies that were the predicate of that. It cascades.
Oh
there.
Lord, y'all. Next
So
Saturday we're
it's
going to
not
have our
requirement that it's specific
our
but there's
name that
also
tune.
predicate acts
Name that
listed in the
tune.
indictment that prejudice our clients that are problematic as well.
How can you find Young
That-
Thug's case and charges? Hold on, let me see if I have the indictment in front of me. Hold on, let's see. Let me see if I have it in front of me. Calvin, you making it a little. I don't know if I have it here. I have to look for it.
I mean, I didn't mean to, to, always not making, hijack on that position, Harvey. I was just asking the question, what's the state's response as to, deferral or, the issue of whether or not, we say we tried the case, it's declared unconstitutional at some point in time, or you lost.
You see how they turn around and not lift you can't hear her? She didn't turn her mic on.
Why not pause on that, Mr. Harvey? Let me defer that until next Wednesday, and I can check on that issue. Speaking of next Wednesday, September 27th, you said Furman versus the state? Okay, you what? I'm sorry. Okay. All right, let me take it up next Wednesday, the 27th. We're gonna start that day, about 11. Ms. Hilton, I think we were also gonna, did you check on the availability of witness for that day? To continue, the motion to suppress? All right. Okay, Ms. Hilton, you ready to call your first witness in regards to the motion to suppress? Okay, I need 5 minutes, so we're gonna take 5 minutes and then, ready to witness, okay?
Okay, let's see. Do I have the date? The date for what? Calvin, you just watched all of Sylvia's video from the beginning regarding the case. She has read his charges multiple times. Thank you, Angie. It's Calvin, I set all of my my thing in a playlist. Go into my channel and you'll see the playlist. Hey Kim. Kim, you still here? Why is they still Yeah, 35 more minutes. See if they still talking about that stuff. I don't even know what they're doing right now. All I know is a bunch of noise. Ugh! Yeah, that tangerine helped a little bit. I don't feel an itchiness. Jason, is this your first time in this channel? I mean, Calvin, not Jason. Calvin, is this your first time in this channel? Did you just started following YoungThug stuff? Oh, Kim, I wanted to tell you, yeah, remember Burger King thing yesterday? I don't know if you heard that Burger King person charged me $27 for a burger yesterday. So I went back there today to get my money back, and they gave me the whole money back, all of it. And she said, I'm not going to charge you for the burger. Good night, Carolyn. Yeah, $27 for a burger. Yeah, I'm starting to get sleepy. Kim, I thought I was going to stay up with you, but I'm getting sleepy. Hey, Stephanie, what are you still doing up? Stephanie's up, y'all. She popped out of the bushes. Stephanie, go to bed. Oh, yeah, I'm about to go to bed. I try to see if they're going to say something else, but they're not saying anything else. Oh, here you go. Steele's going to say something. Oh, here you go. Here comes Steele, y'all. He about to hear it.
Yeah, hold on 1 second. Can we pause on the witnesses 1 second? Thank you, Mr. Steve.
Oh, let's hear Mr. Steele. Oh, Stephanie, funny. Stephanie, go back to sleep.
Thank you, Mr. Adams, I appreciate your assistance. All right, okay, now we can call, your witness and, witness stand, as I apologize. All right, thank you. Investigator Starks, good afternoon, sir, sorry to keep you. Can you approach Deputy Ingram if you wouldn't mind, before you sit down, turn and face him and be sworn as a witness?
Thank you, so the first, okay, speak up.
First name Javarius, Jarvious. Last name Starks, Starks.
Investigator Sparks, good evening. Where are you on board?
City of Atlanta Police Department
And how long have you been with the City of Atlanta Police Department?
since 2012.
And where are you currently assigned with the Atlanta Police Department?
The gang unit.
And what do you do with the gang?
We go out, make contact with gang members, get identifiers.
Yeah, I think it's possible, Angie.
Gang profiles to work up a gang profile for the Atlanta Police Department. We take pictures of tattoos. We investigate crimes involving gang members.
And you sometimes send other units, other departments with the apprehension or looking for other people.
Yes.
And taking you to March 17, 2022, were you working with the gang unit?
Yes.
And while working with the gang unit on March 17, 2022, were you asked to assist the homicide unit in looking for a suspect?
Yes.
What vehicle were you asked to look for?
A white Audi, tinted windows, Maryland tag, the number 8, Edward David, 7071.
And what was the area, was there a specific area in which you were asked to look for this vehicle?
Yes, Cleveland Avenue.
And on March 17, 2022, did you happen to see the vehicle?
Yes.
If you could tell the court what happened or where you were when you first saw that vehicle.
Yeah, so after roll call, I was pretty hungry, so I went to Chick-fil-A on Cleveland Avenue to grab food. I was in the line and then I saw the white Audi put into the Chick-fil-A.
And where were you in the line? Where did you my
It was pretty busy, maybe, I was like 6 cars from the drive-through, from the drive-in. And I saw the Audi put in, so it was probably 5 or 6 cars behind me.
And did you know that was the actual car that you were looking for?
Yes,
Okay, how?
I verified the tag.
How were you able to see that the car was
I got out of line and actually went behind them, and I was like 2 or 3 cars behind them, and then I verified the tag.
What happened once you verified the tag?
Yes, ma'am. I called my supervisor immediately over the radio and got additional resources to make a contact with the vehicle. I got our helicopter unit, GSP, which is Georgia State Patrol, auto theft unit, and other undercover officers to come to the area.
And at the time, let's say that you had, were you in a marked vehicle or a
Unmarked vehicle. Unmarked. It was not marked.
once you notified, so your helicopter unit, GSP, and other APD units, what did you do?
So we waited maybe 10 minutes before resources got to the area.
And what were you doing?
The area unit, Phoenix, GSP, and other takedown units.
And did those other units, or did some of those other units come to the area?
Yes.
And specifically, I mean, you said it's a Chick-fil-A on Cleveland Avenue. Where on Cleveland Avenue?
This is East White.
Once the other units got to Chick-fil-A, what happened next?
So, like I said, we were there 10 minutes, and I believe the helicopter arrived first, and that's when the Audi pulled out and made a right onto Cleveland Avenue.
And when the Audi pulled out and made a right on Cleveland Avenue, did you follow behind the Audi?
I had like a V6, so I couldn't keep up, but the helicopter unit began to give the direction of travel of the Audi.
After the air unit began given the travel of the Audi, did that include your portion of the activities on March 17, 2007?
Yes.
2022?
Yes.
All right, no further questions.
Cross, Mr. Shard and Mr.
Investigator Starks?
Yes,
Investigator Starks, how you doing? My name is Max Sharp.
yes, sir.
So, on that day in question, 17th, you indicated that you were given some information, identifying information about this vehicle. When were you given that information?
Maybe 30 to 40 minutes before I saw the vehicle.
Who gave you that information?
Somebody in the office, I'm not sure. I think it was Sergeant Price.
Okay, and did you have the information written down?
It was a simple description of the vehicle, so I didn't have to write it down.
Okay, but how did you know the tag?
They gave me the tag. Sergeant Price gave me the tag.
And you had it memorized?
Yes.
Were you in the car alone, the unmarked vehicle that you were in? Were you by yourself?
Yes, sir, I was by myself.
Okay, so you get behind this vehicle, and then you said you gave some information. Was it over the radio?
Yes, sir.
Okay, what radio?
Our handheld radio that we get at work.
Okay, and is there a specific frequency that operates on?
I may have been given it over the 10th. The radio was on 3. I'm not sure what channel we were operating on that day. But it's not, we use different channels throughout the course of the day.
Okay. And do you recall, well, first of all, are those radios transmissions recorded?
Yes.
Okay. Were those transmissions from that day preserved?
I'm not sure. That's not my job.
Did you, and to your recollection, what information did you give over the radio?
I gave out my location, which was a Chick-fil-A. I gave out the description of the alley, and I gave out, I guess, how many people were in front of him and how many cars I was behind him.
Okay. Did you, I know that you said you were looking for a car with tinted windows. Did you make any identifications of anyone inside the car?
I don't remember if the windows were up or down. I think they were up, but it had heavy tinted windows on it.
So that would be no, you didn't identify anyone within the car.
No.
And I know that you just testified you gave this information over radio. Did you make any specific calls to any individuals to tell them, or was it just whoever was on the radio?
Whoever was on the radio that day.
I don't have anything else. Thank you.
Anything further from the state? Mr. Harmon, I'm sorry, I don't know if that's the term.
It's investigator Starks, correct?
Yes, sir.
Investigator, when you called out the information that you had, correct? You called out just a regular radio transmission?
Yes.
Okay, and that was to a general radio frequency or a specific radio frequency to APD, or did you, was that just APD?
I'm not sure who's monitoring the channel, but it's APD channels. Any local jurisdictions can monitor our channels as well.
Okay, so it was the APD channel, but you don't know who was monitoring those channels at the time.
I mean, it could be hundreds of people monitoring at one time.
And you said helicopter, and that's the Phoenix unit, correct?
Yes, sir.
And who runs that Phoenix unit?
Who runs it? What do you mean?
That APD?
Yes, it's APD, yes.
It's part of APD, correct?
Yes.
And the Phoenix unit is the helicopter unit, correct?
correct?
Yes.
Okay. Did you have any communication with that helicopter unit? So teammates?
I raised the resources on my radio, and that was one of the resources that I raised.
Okay, that's great. Well, once you said they arrived first,
Yes.
did you have any direct communication with those folks in the helicopter? That was the question.
As I stated, I raised them on the radio, so they heard what I said. So they heard everything that I said among other people who responded to the scene. So I did talk to them as well. They heard what I said.
You talked to them. They talked to you.
Yes.
Okay. And did they provide you with some descriptions of the vehicle?
No, I don't think they were aware of the vehicle. I told them the description of the vehicle.
Right. When they arrived, did they provide you with information about, for example, direction?
Yes. Once the vehicle made the right out of Chick-fil-A, they began to call out the direction of travel.
Okay. And I understood that you were behind that vehicle, correct?
In the Chick-fil-A parking lot, I was.
Okay. And after that car left, you attempted to follow?
Yes.
Were there other marked police cars ahead of you?
Not ahead of me, no.
Okay, so there was not an East Point unit ahead of you following that vehicle?
Not that I saw.
Okay. And you didn't follow that vehicle the whole way until it arrived at the location, did you?
Can you repeat your question in a different way?
I understood that there was no other law enforcement vehicle between you and the vehicle that you were following. Is that right?
Yes, correct.
Did you continue to follow that vehicle until it arrived at its final destination?
My vehicle was slow. It's a V6, so I wasn't able to keep up. So when it sped off, I just followed the directions from Phoenix and looked for the vehicle that I was not able to physically come to the vehicle until it stopped.
Did you see, before you ended your pursuit, did you see any other law enforcement vehicles go past you?
Yes.
And was one of those an East Point officer?
I'm not sure. It was several police on the scene, so I'm not sure it was the East Point Georgia State Patrol or Atlanta Police. I'm not sure.
Okay.
It was a ton of police there.
Well, a ton of police, there are a number of units there, correct? From suppression unit, your unit, Phoenix unit, East Point, a number of jurisdictions, correct?
Yes.
And I also am interested to know, Investigator Stark, so you prepared a report about this incident.
I don't believe I did a report on this because all I saw was the car make a right, and that was pretty much it. I don't believe I did a report on it.
Okay. Thank you, that's all I have. Anything further to have to say?
In case of days to watch the Phoenix video,
Yes.
and did you hear yourself on the Phoenix video?
Yes.
I'm gonna show you, push the approach.
Amen.
I'm gonna show you what the market is. Do you recognize her exhibit number two?
Yes.
And how do you recognize her exhibit number two?
Number two.
Is that the video that you watched today?
Yes.
Okay, and is that a fair accurate depiction of you and your employees, as you were at the Chick-fil-A on March 17, 2022?
Yes.
No, what about that?
Anything further, gentlemen? All right, may I excuse at this point in time for purposes of motion, investigator Sharp, permanent and temporary for purpose of motion? Okay, all right. Investigator Sharp, I'm gonna permanently excuse you for the purposes of this motion, probably be subject to being called later. Don't discuss your testimony with anybody except the attorneys in this case, okay?
Thank you.
And thank you for your patience, please.
Yes, sir.
All right, call your next witness now.
Your Honor, they call Officer
Officer who?
Light Tech,
Spell his last name for me.
Lightkate.
Hey, natural and all.
Start playing testimony, giving the truth, all truth, nothing but truth, sir. Have a seat. Speaking to the mic, loudly. Announce tell the first and last name, please.
My name is Officer Eric Lightcap, ERIC. Last name is LIGHTKEP.
And Officer Light Tech, where do you work?
Atlanta Police Department.
And what do you do in the police department?
One of the police helicopter.
How long have you, is that in a particular unit?
It is, yeah, it's in the air unit.
It's in the,
Air unit
how long have you been with the air unit?
per second.
Directly attended to March 17, 2022. Did you have an occasion to assist the homicide unit in following a vehicle?
Yes.
And how did you get involved in that?
Just like any other call, we usually just stand by once we're raised over our, what we just call SOS dispatch. We respond to whatever we're asked to respond to.
And where is the SOS dispatch?
At the main headquarters, the SOS refers to just a channel.
I'm sorry, where is the air unit housed?
Sure, we fly out of Hartsfield on the north side, Delta Hangar.
And do you, when you're called to an area, do you come from that location to the location where you're asked to visit?
Yes.
Taken to March 17, where were you asked to visit?
To the best of my memory, we were called to assist to the Zone 3 area near Cleveland Avenue.
And were you able to get up and go over the Zone 3?
Yes.
And today, have you had an opportunity to review the Phoenix video as it relates to what occurred on March 17, 2022?
Yes.
And in reviewing that video, was that a fair and accurate depiction of what occurred on March 17, 2022?
Yes.
Yes, ma'am.
I'm showing you March 6th to the number 2. Do you recognize 6th to the number 2?
Yes.
How do you recognize it?
Initial and dated it today.
And that, what's contained on that jump drive?
That's the footage of the helicopter video.
And is that how you recall seeing it on March 17, 2022?
Yes.
Your Honor, just on the state, like the tender states you did the number 2 of the evidence. For the
And
purpose of
objection
hearing.
states to the purpose of motion. States to for purpose of motion, didn't. No problem.
Thank you for the bless me. Need to do some crunches on the floor. See if I could do some crunches, y'all. Don't talk about me. I struggle down here. I'm not near the computer if y'all typing. I'm going to do some push-up crunches, side bends. I had to stop that thing because it was boring. Okay, that's it for that. Okay, that's it for that. That's it from the recording on that one.
First and last. Okay, speak up. First name Javarius J.
Okay, I did that one already. Hold on, y'all. Let's see if we got another one. Let's do the one from Thursday. All right, I'm ready to do my sit-ups, the crunches.
Yeah. But I can understand. Okay, Juror 316, good afternoon, sir. How you doing? Good afternoon. Sir, let me see if I can summarize your walk with us. Sometime in January, we called you in and you had the juror orientation and then you saw a juror video, correct? Yes. And then I want to say the following week or thereabouts.
Okay, this is gonna be boring. Let me move that one. Hold on, y'all. Hold on.
Okay.
You said it needs to be done. You tired?
Your permission is to go
Hold on, let me go.
ahead and
Hold
ask
on.
you some questions based on that, the responses that you gave in that questionnaire under oath. Can I do that? All right. Okay. All right. Does apply. All right.
Your ability to serve as a juror. Well, I was.
Okay, let me ask you gotta ask you several other questions.
All right, we had to get away from the juror stuff. That's boring. Now we're gonna get into regular stuff. Well, guys, I'm about to take my butt to bed, Kim. Yeah, I need to get on workout regimen too. Let's start doing it. Yeah, let's do that.
Councils, just go through some housekeeping just for a second. For Friday, the 22nd of December, September, we are commencing again approximately 11:30 till about 2. We have 3 jurors we're going to examine tomorrow, and those jurors are the following numbers: 365, 368, and 369. Again, 365, 368, and 369 are our jurors to be examined for tomorrow, starting at approximately 11:30. As you all know, on Friday, every second Friday, traditionally have Veterans Court. I have another session of Veterans Court tomorrow, to commence at 8:30. Unrelated to your business, but as soon as I'm finished with that, I'll be here for the juror examinations for those 3 jurors: 365, 368, and 369. And then we will conclude for tomorrow. Monday the 25th is consistent with a request put in by Mr. Weinstein. Being Yom Kippur, I will not hold court on that day. It will be an administrative day for those of you that do not celebrate Yom Kippur. And We will commence again on the 26th of September, that is Tuesday. We will start and commence at 9:30. We have jurors to examine. We have a witness list update. We have discovery, formatting of the drive, and the index to deal with. So Miss Van Council give me the jurors. I don't think she's giving them over. Let's see. What do we have them? For Tuesday. Do we have them already? I think we do, don't we? Repeat those again, Wes, please, please. Good in the order. And additionally, from on Tuesday the 26th at 4 p.m., we will take the testimony of investigator White on Williams of motion to suppress number 9. 4 o'clock. The 27th, we will continue with the administrative issues involving discovery and the witness list drive, and then I will continue with the motion to suppress Billwell and Nichols. I understand there are 3 witnesses to be called, as I understand. Is that correct? And I'm representing to the court that it's going to take a couple hours or three to finish 1 or 2 of those particular witnesses. Is that correct? Are there 3? Okay, that's what you told me. All right, okay. Mr. Short and Mr. Harvey, in regards to the constitutionality of the gun statute, I know we have said we would take that up on the 27th. It is the court's thinking at this point in time, just to be totally candid, that what I'd like to do is to wait as long as I can until the jury's almost in panel. And either 3 things may happen by that time. The U.S. Supreme Court will make a decision, the Georgia Supreme Court will make a decision, or I'll make a decision. One of the 3. I will need to make a decision in the absence of any one of those 2 bodies making it. So I'll be prepared to let you argue and make a decision at that point. Sure, you're welcome to do that. I believe that the state was, you were going to talk to the state about that. That's whether or not they would concur in that issue or not. But I believe I would have to handle both because there would need to be a complete ruling one way or another. So, whatever collateral consequences of that would be certainly something that I can't forecast, but we'll see what happens. Okay. All right. Thank you, sir. Well, on Wednesday the 27th? Yes, ma'am. Hold on. Okay, yes, Mr. Steele. Wednesday, at the 27th, sorry, 11 a.m. Yes, sir. Yeah, all right. That's the next I can tell you all that the 28th and the 29th, I have, well, I can do at this point in time is to block the 28th and the 29th as, at least from 9 to 2 for potential discovery. It'll be attorneys only. I have another unrelated criminal matter I have to take up, on another case that I still am shepherding. And, I will be in the courthouse and, I'll talk about those days. You need to reserve those days at this point in time. That's the 28th and the 29th. Those would be, administrative discovery work time, 9 to 2. All right, let me go back to today and the issues of today. All right. Ms. Love, you were supposed to let me know about this GCIC issue.
Yes, Your Honor, and thank you for allowing me the opportunity to research that issue. I checked, and the Georgia Bureau of Investigation, Georgia Crime Information Center has a GCIC operating and policy manual. Ms. Hilton will bring the relevant portions to the court and to counsel for the defendants. I'll give them out actually, and they can take the whole, you can get the whole copy to the court.
Sure.
And the relevant page is page 53, Your Honor, if the court is looking at the whole document.
I am.
Okay. Page 53.
Okay.
At the bottom, CHRI is defined in the previous paragraphs, but its meaning is criminal history record information, not in the possession of prosecutors. When FBI criminal history record information has not been previously obtained by the prosecution for its own use, access to the information by the prosecution to obtain criminal history record information about the defendant or witnesses solely on behalf of defense counsel may not occur. A court order should be sent to the FBI CJIS division, and then it gives the address. The FBI will provide the court with the requested records accompanied by a letter requesting the court to review the criminal history record information prior to providing it to defense counsel and prosecuting attorney to ensure that it is relevant to the matter before the court. In the manual itself, the first portions of the manual that I've given to the court, as I said, it gives the definition of the criminal history record information, CHRI, and it also gives the definition of I, and we have on staff at our office a person who is responsible for ensuring that we are GCIC compliant. And I was able to obtain this information from that person.
Okay, so I'll consider this court one for the purposes, or the next court exhibit for the purposes of this issue for the record. So it appears to me, in looking at this particular language, if I'm reading this correctly, if the records are not in your possession, you don't run them yourself. Right? So if you run them for your own purpose, then you can give them or provide them to the defense.
As we do, yes.
As you do.
Yes.
But if you don't, that in order for these type of records to be had, the court has to, upon a court order would have to be issued to the, or sent to the FBI, is that correct?
Yes, and also, Your Honor, I believe that the there are two things that I have as a means of obtaining those. I'm certain that perhaps counsels or the defendants may know better than I about this. I know that they are able to ask or make those requests of the records from the center itself, and there is a provision that allows for indigent defendants to have those records run at no cost. And I know that in this same manual that there is a provision regarding the access that the public defender's office has to run. They are also an agency that is allowed to run criminal histories, but they run it under a different code than we run ours.
Sure. I believe that issue, the issue was both issues are kind of touched upon yesterday. The first one being that the issue is that certainly the defense counsels can do that. It's just a matter of it's economically prohibitive or challenging, I would say, not really challenging, because I believe that the 25, how much is it per record? Anybody know? $7 per record?
I believe I've never attended. I checked that for a second.
Sure. I would probably concur with that, Mr. Harvey, but the challenge is that by order, I need to find out which belly button to push, because if I send an order, I could send an order to the GBI, right, or this bigger end and say, hey, turn this stuff over, Sixth Amendment. Well, then you're gonna have it, maybe they turn it over, or maybe they tell me they send the Attorney General over here and tell us the pound saying we're not going to give it. Now, I agree with you, and that's why I said yesterday that the Sixth Amendment trumps this particular record, right to get these records. Ms. Love's concern is that if, and rightly so, since your office is licensed to run these records, they have some pretty draconian, and they have compliance, so they have to stay in compliance. So that's why they're kind of being cautious about it. I do believe that there's, if I hear this correctly, if they run a record, they've got to turn it over to you. They're going to have to. If they don't run a record, you want the record, you're going to have to probably either by court order have me go ahead and do that, which I would probably do. I can have you send it to the GBR, I can send it to district request. I need to do it early enough so that you all can get it or have that at least. All right. Am I telling you something, huh? Okay, all right. Okay, all right. Okay, all right. That's a good question. Have you, madam?
If they happen, we,
That's what we have provided. We get into one that's part of the discovery, when we run it, put it in the file and turn it over. That's a general practice. We have a clear set practice, would not deviate from that. We do not have a separate secret that you guys can do.
Well, here's my concern then, probably theirs. There's another 308 witnesses that they're having to account for. So have you run any records on any of those 308?
I'm sorry, but
Have you run any GCIC records on any of the additional witnesses provided after September the 8th of 2023? Some 308, 307, 308, depending on the count.
now that hasn't been provided. And when people try to convert as well, as we are required to do, because that's in the discovery section.
Okay, yeah, okay, all right. You may.
there are the original
That would be a thing to do. That's we can do that. What we can do, as we have to, is when we have to find the program. Certainly not to refund someone that's gotten an arrest that, different than what we, so we've not done that, and we have to.
Can you, it looks like, it looks like the probation parole can run them or whatever else.
That has different purpose.
They have different purpose codes, okay, all right. But are you telling me that, if you learn of a new conviction either through one of your colleagues from the other jurisdiction or, that be state or federal, you couldn't run another update?
Right.
Is there a code for an update?
No, it's access to the, Georgia Information Center. That is, that access, that's being compliant with, it's not retroactive to something that was already done. And so the continuing inquiry is access to the terminal. The Georgia access.
So you can't run an update, or if you run it once, you can't run it again?
Right, that is correct, that is correct. Yes.
I'm sorry.
They not under the same circumstances that we are discussing here. If we are looking for someone. Grant, take criminal history for whatever that person was doing through the case, after term. And so that's the circumstance that we are.
Boring.
That's what we have.
My throat's starting to itch again. I guess the tangerine more up.
Okay, Your Honor, I was working on our case, so it's down, it's just, I apologize.
Well, don't worry about it. I got you.
And thank you. So, Your Honor, the state is right. So if I just came to anybody who has the authority to run a GCIC or NCIC, they're protected. There's a lot of information on people. So you have to have a worthy cause or lawful cause. So what I disagree with the prosecution is the word can't. They can't run it. They have total discretion. They can run it for witnesses in a case. I can ask for witnesses in the case. I will do that. It takes me a lot of time to do that. Put everything in writing with all the witnesses' information. And we could do it. I got great co-workers who will work on it all day. Then we have to properly mail it. I think there's a portal. It says mail, but I think there's a portal. and we know the lawyer for the GBI, so they're very helpful. We have to pay the money, and they will get back to us within whatever time period they allow. But it is discretionary with the prosecution. They are not barred by statute or by policy.
It says may, I think, so.
Exactly. Yeah. If they understand the circumstances they put people in here, and they would just have a little, meeting and say, this is the right thing to do, and the professionals would assist a little bit with time management. That's what I would ask. There's nothing preventing them. It would not be a breach of their duty. If the person wasn't on the witness list, or wasn't going to be a witness, or, this was for another case of Mr. Matthews, yes, that would be wrong. Doesn't deal with this officer. This is our case, so I would like some, professionalism and some kindness based upon the situation. That's why I don't believe that there's any reason not to do it. And they would not be, and they could tell the GBI, this is what Seal asked, this is what the judge is asking, is it okay to do it?
Can you make an inquiry in the GBI as to whether or not that can be done?
First I called, the moment that they respond, they ask me to do it. Because we have been trying to get certain that we have all the answers of the outside that work this going on.
Yeah, I mean, and I think it might be appropriate to maybe reach out to your counsel to figure out, just because I read that statute as being you may, you have discretion to do that, and I've been sitting here thinking about it would certainly go a long way and mitigate prejudice, because if you have 308 witnesses after September 8th, and I'm still going to have you answer the question why it is that you took so long to tender these witnesses, because that's just too many. I mean, anybody, even if I have to weed through it and excise those people that aren't really relevant to the case, never be called, whatever else, I still got to prepare for them, just in the off chance that something is presented that makes them relevant now. So I think that it would be wise if you all kind of did that, because if not, I can tell you, it's gonna lend itself into prejudice. It really will at this point.
I will call general counsel in a minute. And our information that I will get the information from the court. Now, I will make the same for you for that's to be sure.
Okay.
I do not jeopardize.
I understand. And it may just be the number of records you have or whatever else, or maybe you call down and decide, well, these people aren't going to be called or whatever else, and that lessens your universe. But you got a lot of folks you got to account for, and so you take care of that, and then once we get an answer in terms of that, I'll make some other decisions, and to include Mr. Steele and Mr. Harvey in order, either from the court directed to the GBI and or the NCIC to procure these records. Okay.
I don't know how that would work with that part.
Well, if it looks like the first course of action, the most preferred course of action would be you exercise your prosecutorial discretion and run the records once you get clearance and you're satisfied that you can do so. That'd be the number one option. Option number two is, in the manual, is for the court to issue an order saying to the GBI, saying, putting into account what Mr. Steele and Mr. Harvey mentioned. Here's the people. Here's the things that we need, and here's why. That they're potential witnesses in this case, and or These witnesses were disclosed by the state. I'll let them figure out a suitable order. Then I will sign that order and I will send it to the particular entity that's listed on page 58. 53? I'm sorry. Let me put my 53. So yeah, I've got it here. So I can. Yeah, I mean, I'm willing, Mr. Steele and Mr. Harvey, to send it to both the portal or to general counsel as well as to this particular address with the FBI. I don't know how long it will take, but I'm willing to do either one on those two. When can I find out Miss Love, you said as soon as you found out something, you would let me know, let us know. Okay, all right, so I'll continue with that. All right, before we release for the day, I believe that for Monday, ladies of the state, we're gonna update the witness list. That's supposed to be updated on Monday, is that correct? Can you provide that, is that right?
No, Tuesday.
Tuesday, I'm sorry, it's Tuesday, it is Tuesday, yes, it is Tuesday. And then we're gonna talk a little bit about the formatting of the drive, and you're gonna give me some updates about that and the formatting of the index, is that correct? Mr. Steele, do you have your supplemental questions that you wish for me to propound or ask or inquire about in writing?
Yes,
Okay. All right. As soon as that's taken, as soon as it's filed and the state's had an opportunity to respond, and then that should give us a little more time to kind of take a look at some other things I mentioned yesterday. So I will go ahead and do that at that time. All right. Wednesday the 27th, we're going to do the continuation of motions pressing. Ladies, you're supposed to give me an update on the formatting and transfer to the fast hard drive. Is that correct? And your evidence index supposed to be ready? At that point, that's what I have on my notes here. That's still the case? Okay. Okay, all right. And Mr. Weinstein will prepare the discovery order. And we're supposed to call some call the witnesses in Stillwell and Nichols. The flight logs or whatever. Well, I don't think they have them. That's yeah. If he's subject to being recalled. Okay, so ladies, can you provide that? Just so that if we have to supplement, I told it, I mean, the defense says they would like to, depending upon what's produced, to see whether or not any recall or supplementation of a motion would be necessary, okay?
Yeah.
All right, so can we do that by Wednesday?
Yeah, we're gonna be okay. At this point, we had 3 came up, so our attention are, we really need video with the entire case, or all of it.
Okay. All right. All right, and then consistent with what we've been talking about already in terms of the discovery and other issues, that's why I put down, I will be here. Like I said, I have another matter I take up that's been scheduled for a while on the 28th and 29th of September, but I'll be in the building. And but I don't want you all to block those times I mentioned earlier, so you can work on any discovery matters that you have outstanding. So, okay, questions? All right. Okay, well, unless you have anything else, folks, then I will see you all Tuesday morning, the 26th, at No, you're right, sorry. I was looking ahead, that's right, I got so many things on my calendar. I'll see you tomorrow for 11:30 to examine those three jurors, okay? All right, we'll see y'all tomorrow. All right, we're in recess.
All right, guys, I'm gonna end this now. All right, and I will say good night to everybody. Good night. Sorry, wrong button.